Welcome to the Respectful Divorce Podcast. If you're considering divorce, it's important to know that you have options for how you divorce. On the Respectful Divorce Podcast, we explore those options and provide advice from divorce professionals. I'm your host, Tim Crouch, and today we're talking with an Ohio collaborative divorce attorney, Nancy Sponseller. Nancy, thanks for joining us today.
Well, it's a pleasure. I'm really excited about providing some information that may help people to make some decisions that are important in their life.
Great. So let's first of all talk about you. How did you end up as a family law attorney?
Well, I didn't want to do this when I was in law school, I tell you. I first started out doing solid franchise litigation with one major company throughout all Ohio. And there were 13 or 14 franchise companies. National companies decided that they did not want to do any litigation to resolve their disputes. And they formed a PAC and put in their agreements that they were going to arbitrate or mediate every dispute between a franchisor and a franchisee. Well, that eliminated my work in Ohio. But at the same time, Ohio was changing its domestic law. And there were seminars just all the time about the new law. And I was having people call me and ask if I would represent them in domestic disputes. So it was just an opportune time to get into that area of law. And at the time, I will tell you, it was all litigation. There was very little mediation. I never heard the word. And there certainly wasn't any collaborative divorce work. It was all litigation. So that's how I got started. And my litigation skills did transfer very easily. But there was a difference between litigating family law matters and franchise. Franchise, it was all about companies and money and not about human relationships in a family. And there was a time when also it became very apparent that exorbitant amounts of money were being expended by families in litigation just to get basic information that should have been available right out of the gate. I had one case where a lady spent about $80,000, I never will forget this, to just get information about what her husband had in his name. And it took a long time and 4 trips to the courthouse to get him to produce. And there was a time when I said, this is just not working for me. This is disgusting. This is distasteful. And then there appeared on the horizon, and I think it came out of California, maybe Minnesota, something called collaborative law, collaborative divorce. And there are a group of us here in Columbus got into this and we started reading about collaborative. And they were of like mind. And they said, if they're doing it in Minnesota and California and other states, we need to look into this and see if this is a viable option for people in Ohio. And we went to there was the board of commissioners. I mean, we had to get a letter that basically that this was legal, that we could settle things in this way. We got that. And then we were off to the races, being trained by people who came into our state from Minnesota, California, Florida, other states. And we started, it was about 22 years ago that we started the collaborative divorce process in Ohio, in central Ohio.
So what is it that appealed to you about collaborative? What's different about it for someone who's looking at that question of how their divorce might be handled?
Well, there is no really easy way or stress-free way of terminating a marriage, but this is the best way and with the least stress. And I think once people understand what the professionals, both the attorneys that are trained and the neutrals that are in the process, that were designed, that we're trained to work together to help them resolve their matters in the best way for everybody. And, we used to hear in law school about win-win results with company disputes. This became apparent that it was a win-win process for families, for husband and wife in terminating their marriage. So, I saw that right from the beginning, that it was the best way. And frankly, the other attorneys that were interested in this and trained in this They were not barracudas, and that was distasteful to them. So they were not going to come into this process bringing their barracuda, litigation skills and want to beat you down. This was actually a process where we could sit at the table, fully trained, look at the issues, look at the options, help the couple go through what their options, their realistic options were, all of them. Make sure they understood their options. Make sure they understood the law if they wanted, if that was relevant. And it was just a better way, a much better way to terminate a marriage and leave the parties in the best possible position that they could be in, given that the marriage was being terminated.
So, what makes it a win-win in collaborative versus a win-lose in litigation?
Well, in litigation, there usually is one person who can win or take all. That's true. I mean, you see it, and you hear about it. In a collaborative, may I just say there's appropriate compromises along the way, and the parties have the ability to assess what's an appropriate compromise and not leave the other with nothing. I mean, the idea is to strike a balance and to have something that's fair and equitable in a meaningful way. And so we want to have a life after the marriage is terminated for both of the parties and their children. And we have only so many assets and so much income to work with. But we try to maximize that for everyone, if to the extent we can. And we think outside the box. We come up with some solutions that no court would ever, consider. But we can consider, and if the parties want to consider something that the court would not order, then we do. We talk about it. And I've seen a number of cases where there's been some creative work done that has just been outstanding. But I think coming into the process, and I can say this really for all the professionals who are part of our collaborative group here in Columbus, there's an attitude that they bring into the process of fairness, of wanting to work together to get this done in the best possible way. And you come in with that attitude, competency and consideration for everyone. I tell my client, now I'm going to be nice to your spouse. Understand that doesn't mean I'm buying everything he's saying or she's saying. But I want him or her to like me and to be able to say, I can come back into that conference room again and work this out. We all want to feel that. And I think that's when people have come in after the first meeting and they get more relaxed and they see who we are and what we're doing, then they can come and finish the process. They want to finish the process. They don't want to take an exit out and say, well, I'm going to be down at the courthouse, which is voluntary. I mean, they could do that. They could leave the process if they chose, but they choose to stay in the process and work with us to get this resolved.
So you talk about the us. Who is the us?
Well, each party needs to have a collaboratively trained attorney, and I say there's training, there's serious training involved. We just don't get into this process and say, well, I can settle a case. Okay, we've had serious training from people who have committed their careers to the collaborative process around the country who are well known. And so we have a list, and each party to a marriage is to select an attorney, a collaboratively trained attorney from that list. And then we have neutrals. We have a neutral family coach, and we have a neutral financial expert. The neutrals don't represent either party. They are neutral. They're coming into the process. The financial expert is the person who's going to gather all the financial information from both parties and schedule it out. What are the assets and the debts? What's the income? And we may look at the income for the last 3 or 4 years. What do the tax returns reflect? Get all that financial information right out of the gate, right up front, and it's assessed by the financial neutral. We're not spending $80,000 to figure out what these people have. It's just produced automatically on request by the request of the neutral family financial expert. And we look at that usually at our first meeting when we gather as a group of 6 And so the we would be two trained attorneys, collaboratively trained attorneys, a financial expert, neutral financial expert, and a neutral family coach, and the two parties. Now, the family coach is a person from the counseling background, but I tell people quickly, this is not counseling and this is not therapy. But this is a person who is trained in communication skills, also trained in knowing what the hot buttons are that have brought the parties to this point that they want to that they need to end the marriage. That most of parties who are in this process are living at a point in time where the stress is unsustainable. They've got to do something. They know they don't come into this process willy-nilly and just think, well, I think I'd like to get divorced today. Usually they have given this serious consideration and have counseling over a period of time. And they come in because they feel they're at the point where there's no choice. And maybe both parties feel at this time that it's best. So the we is a team. We as a team who are committed to help this couple through this process to resolve all the issues that the law requires that we address and agree upon, put in writing, put in agreements that file with the court, put in an agreement if there's minor children and a parenting plan, file with the court. So the we is a team. And I think when they're in the process, they start seeing the teamwork at the table in the discussions.
Now, there are some people who, without getting all the information, might think, "Oh, I got all these people involved. This is going to get really expensive." But it still is a more economical process than if you end up fighting it out in court, right?
Yeah, absolutely. And so if you have, people ask me, how much is this process going to cost? Well, if I look at it in terms of the hourly rate of the professionals who are at the table, we usually have 2-hour meetings. So you can do the addition. The neutral family coach has an hourly rate. The financial expert has a rate. The two attorneys have their rates. So sometimes we say, well, it might be $2,000 a meeting. But here's the thing, and we have 2-hour meetings, and we may have 3 or 4 meetings 2 weeks apart. We have an agenda. We know what we have to address. We have homework, so people come in prepared for that meeting and prepared to consider options and make decisions, or maybe make decisions at the next meeting. But here's the thing, the financial neutral is a good example of the person who takes on him or herself the professional duty of gathering the finances, and it's one person doing it, and it's the person who is the most qualified to do it, and at a lower hourly rate usually than the attorneys. And we're not having 2 attorneys do the same work and fight over what needs to be on the balance sheet. Okay, we have a financial expert who does all that. It's extremely efficient, and we have all of that right out of the gate, usually scheduled at our first meeting. And then we can springboard into goals and interests of the parties, looking at what they have to work with. What are their goals and interests that they want to achieve in this process? Is the home going to be kept by one party? Is it going to be sold and the proceeds divided? Maybe people come in with a variety of interests, and we go through their goals and interests and what's reasonable given what they have and what they want to achieve.
Yeah, I think the interest piece is really kind of an interesting difference between litigation and the collaborative process. In the collaborative process, you're really in the litigation process, you're taking a position and you're fighting for your position, as opposed to what is it that your goals and interests are, and how do you work together to perhaps achieve that for both parties, right?
Mm-hmm. Mm-hmm. Yeah, and sometimes in seminars we start out with the orange, and we say, well, we split the orange in half, and everybody gets a half of an orange, or maybe someone has an interest in in zest, in recipe, and they need zest. They need the peel, or another party needs the juice. Well, that may be too simplistic for some, but think about it. We can apply that in very real financial cases. So Yeah, and not that this is the only one. I mean, I could think of 100 because I've had more than 100 cases over these years. But let's say, for example, that the parties have a goal and interest in seeing that their children are educated in college. Okay. Now, that is not an issue in Ohio that a court would address. It would say, the kids are through high school. You two parents, you go out and you figure it out. And if you want to pay for college, and sir, if you don't want to pay for college, the court's not going to deal with that. And that's the current state in Ohio. Most people in the collaborative process have a strong interest in seeing that their children are educated to the extent they have the means to do that. And there's sometimes you take from marital assets and allocate things that then would be contributed toward the children's college or post-high school education. It might be a trade school. And that's something that the parents, the parties in the collaborative process can do with the assistance of the professionals and put together and put in the agreements that's filed and becomes a court order. So goals and interests, it's important that we know who wants to keep the house, or if neither party wants to keep the house. But the goals and interests of the parties, and it's usually not when we sit down and start that conversation. I can't recall a case where a party said, "Well, I want half." They usually say something, "I want what's best for our family and our children." Or I want what is fair and equitable. And I don't know what's fair and equitable yet, but I want a sense of what is fair and equitable for us. I've never had a party come in and say, "I want half." But that's where you'd be pretty much in the court system. And you would be trying to make sure that you got the most half. You make sure the numbers the appraisals were high. So, for example, or and you made sure that the half was really half and not less than half.
And in the court system versus collaborative, the court's going to tell you how it's going to be done. In the collaborative, nobody tells you how it's to be done. It's the couple that makes all the decisions, right?
That is correct. And that's an extremely important distinction. But here's the thing. The parties need to know what they need to know. And the professionals have an obligation in this process of making sure that each party knows what they need to know before they can make an informed decision. Once they know, for example, what the school rules are on spousal support, they may decide and set something aside and say, "Well, I hear that, but that's not relevant to our situation right now." And so making an informed decision, knowing what all they need to know, then they are free to make their own decision. I've had one party who said they take all the debt. Well, no court's going to usually allow one party to take all the debt without some accommodations. But, he felt that was appropriate. He wanted that for his wife, who he still loved, and his children. So the parties are free to make their own decisions once they have all the information about what they own and owe and what their incomes are, and what the law provides. We usually cover that at the table. I've had some collaborative cases where parties have said, "I don't care what the law provides. We're going to do what we want to do." But most say, I would like to hear what the law has. So the other attorney and I have this discussion right at the conference table with the parties hearing what we have to say. And then they're going to be free to make their own decisions. And maybe not at the table, not at that meeting. I say, don't put that stress on you. You can think about this and come back to maybe the next meeting or before the next meeting and tell us what you believe you want to do. Because the parties do make their own decisions in this case, in the collaborative process.
So this is the Respectful Divorce Podcast, and we're doing this ahead of the upcoming Divorce with Respect Week. What does respect in divorce mean?
Well, I suppose different parties would have a different answer for that, but I think you treat each person with dignity, and that they are entitled to an opinion. They're entitled to know everything that you know about the finances and the that are involved, the marital equity. That and really that you don't want to do harm to them. You want them to come, the other party to come out as well as possible, as well as you. And the tone, the language that we use in these meetings is respectful. Um, and here's an example too of respect. I've had several cases where in one meeting, both parties broke down and cried. Now, how do we deal with that respectfully? Well, we deal with that respectfully. We don't diminish the person who's in tears. We don't say, "Oh, this we got to end this right now." No, and usually that's when the family coach comes in and does some professional work. But why did they break down? I asked my client why he broke down when we took a break, and he said, "I'm under so much financial stress right now. I can't stand it. I haven't paid my quarterly taxes." He was a doctor. And his wife was spending money on dance lessons, And he says, "I am under so much stress, I'm going to have a heart attack. I've had to take wellness breaks from my physician duties." And go back into the meeting and say, understand why he broke down, understand why she broke down, and talk in a very respectful way and say, how can we move forward at this point? Do we need a further break? When will we meet next? Is this going to be a remaining issue? But I think it's how we approach the people involved. They're human beings with feelings. They're human beings that have worked hard to, build a family, raise children often, work to build equity for the family, and now it's coming apart. And how can we do that in the best possible way? And the tone that we speak and the issues, how we communicate is so important in demonstrating that we're respectful of everyone.
This is not some easy kumbaya divorce. This is hard work, isn't it?
This is hard work. We do not pick the cherries. I'm telling you, these are hard cases. And sometimes the cases, when I get a case coming in, I'm thinking, I don't know at the front end whether I can be successful. This is going to be a challenge. I mean, I'm up to the challenge. I'm up to the challenge because I'm up to helping people. And I'll give it everything I have in all my experience to help people get to a better place in life where they're free of the stress. As I say, they come in, they're in unsustainable stress. They have to terminate the marriage and separate and move on. But there are difficult issues. But here's the thing. We have had training and ideas. And as one trainer will say, we have a lot of tools in our toolbox. And we oftentimes don't know what tools we're going to need until we're in the case and we're working to reach resolution. And then we know what we're dealing with and what we have to work toward and get over. No, they're hard cases, and we don't leave people in impasse. People say, "Well, what if we reach impasse and can't reach an agreement?" Well, it's truly they're free to walk out of this process and go to the courthouse. But before they do that, we have some tools in our toolbox to get them past impasse. More ideas, but there are really hard cases. And I suppose, in all candor, most people who come into this process think that their case is going to be really hard. There's usually one or two issues that they think are the nut we can't crack. And then we get in the process and start talking about all the options and things that they hadn't thought about. And we work it out.
We've been talking with Nancy Sponseller on the Respectful Divorce podcast. Nancy, if people would like to get in touch with you, what's the best way to reach you?
Well, they can email me. I get a lot of emails. Nancy at sponsellerlaw.com. On my, I have contact us information online. Sometimes people fill out those forms and I get those contacts and I get an email from them and a phone number. or they can see my phone number and call me. And I try to pick up the phone, but I try to answer every call that comes in the same day. And if not the same day, the next day, because I know that before they called, they had been thinking about this a long time. And when they called, they were under stress. And they said, now's the time. I got to talk to somebody. I can't deal with this any longer by myself. I need some help. That's why I answer that phone.
Again, thank you for being with us on the Respectful Divorce podcast today, Nancy.
Well, it's my pleasure. And I hope that those who are listening to this will consider this process if they feel they need to move forward in their life and talk about terminating their marriage and living separately from a spouse that they thought they would have forever until death do us part. And that's not the case. But if a party believes they need to even have a consultation and get information, sometimes that empowers people and helps them to make a decision whether they need to move forward in one way or another. So I'm available for consultations, and I certainly want to help everybody who calls.
Yeah. We'll put links to Nancy's website and her contact information in the show notes. This important programming note, Divorce with Respect Week is March 3rd through 9th. During Divorce with Respect Week, you can talk with lawyers, divorce coaches, and divorce financial experts for free to learn more about the divorce process and your options. Simply go to divorcewithrespectweek.com to find professionals near you. That's divorcewithrespectweek.com. I'm Tim Krause, reminding you that collaborative divorce is a better way to untie the knot.